Hello everyone, welcome back to Kalam Academy. You must have solved this 2402 paper, online students. Offline, I can confirm that all the students have already solved this. So let's discuss this paper of polity, right? So this question, there were 50 questions, and the questions, how that questions will be and how that question has been. If you want to share your experience, please comment. Question number 1 says that the Constitution of India, where does the term federal appears? Does anywhere in entire Constitution of India federal word appears? Actually, it's not. Nowhere in the Constitution of India federal word has been written, right? Therefore, the statement will be wrong. None will be the answer. Question number 2. Which of the following provisions of the Indian Constitution clearly reflects the federal character? When we are talking about the federal character, then that does mean that there will be two types of the government, one at the union level, another at the state level. For both the union level and the state level government, the Constitution of India itself has written provisions, and therefore our Constitution has been so lengthy, right? So this is the feature, this is the federal feature, means there will be two types of government, union government and the state governments, and this is there in the second option, that is powers are constitutionally divided between the union and the states, right? As you know that in the 7th schedule, the powers is divided between the union list, state list and the congruent list. So that is there. Answer will be B. Question number 3. Statement by question. Statement 1. Article 1 of the Constitution of India describes India as a union of states. So this is correct. India is called as the union of states. It is not called as the federal, right? Though in the nature of the Indian state is federal in nature, but it is called as the union of state. Second statement is the term union of states signifies that the Indian Federation is not the outcome of a voluntary agreement among the constituent units, and the components states does not possess the right to succeed. So this is what union of states is. In India, the states did not come together to form a union, right? And no states in India has the right to secede from the India. Therefore, we are against this Khalistani movement. There we are against this Nagalism movement, right? So nothing, no one can succeed it, and this is the correct means explanation also. So answer will be 1. Statement 1 and statement 2 are correct, and statement 2 is the correct explanation of statement 1. Question number 4. Consider the following statements. Allocation of seats done by delimitation commission can't be questioned in any court of India. Delimitation commission is a statutory body, and it is formed means time to time for delimitation of constituencies and the allocation of seats, right? So this delimitation commission Act 2002, recent delimitation commission Act 2002 is functioning right now, and it has lots of power. Whatever kinds of delimitation it does, it cannot be questioned in any court of law. So this statement is 100% correct. Election to the parliament or the state legislature can never be questioned. Why? Why it cannot be questioned? The election to the parliament and the state legislature can be questioned if some person who has been holding the office of profit. So whether that office of profit comes under the means whether that office of profit is allowed or not, right? No one can hold any office of profit and can become the member of parliament or the state legislature, right? So such things goes into the High Court. So such questions can be raised. So this statement is wrong. Correct is asked. So only one will be the answer. Question number 5. With reference to the delimitation of the Indian constituency, consider the following statements. Provisions for readjustment and the division of each state into territorial constituency is given in the Constitution of India. Is it? The provision for readjustment and the division of the states into territorial constituencies is given in the Constitution of India. Yes. Article 82 of the Constitution, right? It talks about the delimitation for the Lok Sabha seats. Article 170 of the Constitution, it talks about the delimitation for the Legislative Assembly seats. So that is a correct statement. Constitution of India provides for refixing the number of the seats reserved for the scheduled caste and scheduled tribes. Yes, that is there, that provision is there. Article 330, 332. So in those articles, same kinds of provisions is there, means there can be refixing of the number of the seats reserved for the scheduled caste and scheduled tribes. Delimitation Commission of India is a constitutional body. It is not a constitutional body, it is a statutory body. It has been made through an statute, that is Delimitation Commission Act. There has been 4 such Delimitation Commission Act which was there in 1952, 63, 73, in 2002. So that is a statutory body. This statement is wrong. So only 2 will be correct. B will be the answer. Right. Question number 6. Consider the following statements. The President can declare a national emergency when the security of India is threatened by the external aggression and internal disturbance. Is it correct statement? Actually, on the basis of internal disturbance, the emergency was declared in 1975, and that was the misuse of power of emergency, right? Therefore, this has been removed in the 44th Constitutional Amendment Act when the Janata Party government came. So there is no more internal disturbance, there is armed rebellion, right? Word, external aggression and armed rebellion is the word. So this statement will be wrong on the. Then the President can proclaim a national emergency only after receiving a written recommendation from the cabinet. So actually before 1978 such provisions was not there, right? But this provision came to the 44th Constitutional Amendment Act that the President can only proclaim national emergency on the written recommendation of the cabinet, right? This was to ensure that no such misuse of power for the national emergency occurs as it occurred in the 1975. So this statement is correct. So B will be the answer. Correct has been asked. Question number 7. With reference to the President rule in India, consider the following statements. A proclamation imposing President rule must be approved by both the houses of the Parliament within 1 month from the date of issue. So for the President rule, the governor, it can be applied through the 2 methods, that is either the governor gives recommendation for the President rule, or the President himself is satisfied that the President rule has to be applied, right? So whenever the proclamation of President rule comes up, it has to be approved from the house, is both the houses of the Parliament, by simple majority and within 2 months, not 1 month. For national emergency, the provision is for 1 month, that approval should be within 1 month from in both the houses, right? And this is talking about the President rule. So here it should be 2 months. So this statement is wrong. President's rule can be extended for a maximum period of 3 years with approval of Parliament every 6 months. So this statement is 100% correct. 6 months, 6 months, 6 months, 6 months, 6 months, 6 months. Up to 3 years, President's rule can be applied, but it has to be approved every 6 months. So this statement is correct. Every resolution approving the proclamation of President's rule or its continuation can be passed by either house of the Parliament only by a special majority. There is no need to have a special majority. In case of national emergency and its approval, a special majority is required, but in case of this President rule, only simple majority is required. So this statement is wrong, means that will be only one will be correct. Question number 8. With reference to the President rule in India, consider the following statements. During President rule, President can delegate the power to make laws for state to the governor. Is it correct? During President rule, President can delegate the power to make laws for the state to the governor. Actually, it is done by during the President rule. Actually, the Parliament delegates the power to make laws to the President or any other authority as it deems fit. So this statement will be wrong. Lok Sabha can pass a resolution for its revocation. So this provision actually is there for the national emergency. For the President's rule, there is no need of parliamentary approval for the revocation. The President himself can remove at any given point of time. Right. So this statement will also be wrong. Correct has been asked. So it will be D. Question number 9. Question number 9, please read it. Question number 9 says, consider the following statement in context of the national emergency. So while President rule can be imposed in limited area, national emergency can be applied to only the entire India. That is not the case. Actually, national emergency can be applied in entire area or it can be applied in any part of the India. So that statement is wrong. The declaration of the national emergency is immune from the judicial review. Nothing, very few things are immune from the judicial review. These provisions are not immune from the judicial review. Why? Because the President's own satisfaction is not there. It is the President working on the aid and advice of the Council of Ministers, and Council of Ministers is the government. So Council of Ministers can suggest bad things to the President also. Therefore, this comes under the judicial review. At any given point of time, if the President national emergency has been applied on a qualified regions, right? Therefore, then at that point of time, it can be judicial review will be there and it can be revoked through the court. So this statement is also wrong. Correct has been asked, so it will be D. Question number 10. With reference to the definition of a public authority under Right to Information Act of 2005, consider the following statements. Right. Regarding the right to information, it is asking what the Right to Information Act regarding the public authority. So just by reading it, what do you see? You see the public authority. Public authority will be what? Either that authority must be made through some kind of legislation or by some kinds of constitution made, right? Or government must have been funding those public institutions, right? Then it will be coming under the public authority. So let's see the statement. It includes any authority of the self-government established by the Constitution. If the Constitution itself has established that self-government, why won't it come under the public authority? So that statement is correct. It includes any institution of self-government established by the law made by the state legislature. This will also be correct. It does not include non-governmental organization financed indirectly by the funds provided by the appropriate government. So if any non-governmental organizations is being financed by the appropriate government, it has to come, right? It will be a public authority and they will be coming under the Right to Information Act, right? So this statement is wrong. It includes any authority of the self-government constituted by any law made by the Parliament. So if any authority of the self-government which is being made by the law of the Parliament, then in that case also this will be coming as a public authority under the section 2H of the Right to Information Act, right? So this is also correct. correct has been asked. So statement 1, 2 and 4 will be the correct answer. D will be the answer. Come to question number 11. 11 is, consider the following statements in context of Article 358 and Article 359 of the Indian Constitution. Now, this Article 358 and 359 of the Indian Constitution, it is acting when there is national emergency is being implemented. Article 358 says that the Article 19, the fundamental rights under Article 19 will be automatically suspended whenever there will be national emergency on the basis of external aggression, right? Means external emergency will be there on the basis of war and external aggression and not on the basis of armed rebellion, right? So that is there, it will keep on automatically suspended unless and until emergency has been revoked, right? Under Article 359 of the Constitution, any other fundamental rights except Article 20 and 21 can be revoked or its implementation can be stopped, right? And that will be done through the President's order. It can be done for the entire country, it can be done for the small part of the country, it can be done for the entire time period of the emergency period, it can be done for the small time period of the emergency period, right? So Article 358 automatically suspend the fundamental rights under Article 19, while Article 359 empowers the President to suspend the enforcement of the specified fundamental rights. So this is a correct statement. Article 358 operates in case of both external emergency as well as the internal emergency. So this is wrong. Article 358 only acts in case of the external emergency, and this safeguard has been brought through the 44th Constitutional Amendment Act. Article 358 extends to the entire country, whereas the Article 359 extends to the entire country or a part of it. So this statement is correct. Article 358 does not empower the suspension of the enforcement of Article 20 and 21, whereas Article 359 suspends 19 completely. So this is just opposite, means 300 through the 358, 19 is being suspended, 359 other fundamental rights except Article 20 and 21 is getting suspended. So here statement 1 and 3 will be correct. Now question number 12. Consider the following statement in context of financial emergency. Central government can issue the direction to any state to observe the financial propriety. Why not? Central government, central executives has the role that during the financial emergency they will be saying to the state government to cut down their expenses. So this statement is correct. President may issue direction for the reduction of the salaries and allowances for the employee of the union government except judges of the Supreme Court and the High Court. Now understand, the judges of the Supreme Court, they are charged on the Consolidated Fund of India. The salary and allowances of the judges of the Supreme Court, they are charged on Consolidated Fund of India. Salary and allowances of the High Court judges are charged on the Consolidated Fund of State, respective state, right? So in normal circumstances, this will not be reduced, as these are charged on consolidated fund, so it cannot be voted upon. But when financial emergency is applied, at that given point of time, the President may say for the reduction of salary and allowances of the Supreme Court as well as the High Court judges. So this statement is wrong. It has been declared only once so far during the financial crisis in 1991. The financial emergency has not been declared even once, not in the 1991 financial crisis also. So this statement is also wrong. So correct has been asked, only one will be correct, A will be the answer. Question number 13. Consider the following statement about the resolution of approval and disapproval in context of national emergency. The resolution of approval is required to be passed by the, in case of national emergency we are talking about. The resolution of approval is required to be passed by the Lok Sabha, while the resolution of disapproval need to be passed by both the houses of the parliament. So it actually this is just opposite. The resolution for the approval of the national emergency has to be passed by both the houses, Lok Sabha as well as the Raj Sabha, and that to be passed by the special majority, right? Whereas the resolution for removal of the national emergency will be passed only in the Lok Sabha, and that to be passed only through the simple majority. So this statement is wrong. The resolution of disapproval is to be adopted by the simple majority only, while the resolution of approval need to be adopted by the special majority. So this statement is correct. So B will be the answer. Question number 14. Which of the following option is incorrect in context of the operation of President's rule? President's rule means Article 356 is being applied. Means state's rule will be transferred to the center. Which of these are incorrect? The state executives is dismissed and the state legislature is either suspended or dissolved. That is 100% correct. First of all, the state executives is dismissed, matlab council of ministers of that particular states will be dismissed, and the legislature may either be, it will be suspended or it will be dissolved. This is right. Parliament cannot delegate the power to make laws for the state to the president or any other authority. So actually this can be done, right? The president's rule does not affect the fundamental rights of the citizen. This is 100% correct. The president's rule does not affect the fundamental rights. It just affect the executives and the legislative organ, right? It has nothing to do with the citizen's right. President's right can be revoked by the president at any time by subsequent proclamation and does not require any parliamentary approval. So this is also right. For removing of president rule, there is no need to have any kinds of parliamentary approval. Only in case of national emergency, there has to be parliamentary approval, and that too only from the Lok Sabha through the simple majority, right? So this statement is also correct, and this statement is wrong. Here it should be cannot be there. So D will be the answer. Question number 15. With reference to the contingency fund of India, consider the following statements. You must have heard about the consolidated fund of India, contingency fund of India, public accounts of India. So questions will be asked from there. The total corpus of the contingency fund of India has been 500 crore. So actually the total corpus of the contingency fund of India was earlier 500 crore, but in the finance bill 2021-2022 this has now been changed and it is now 30,000 crore. So this statement is wrong. The fund is held by the Department of Expenditure on behalf of the President of India, and it cannot be operated by the executive actions. So actually the fund is held by the Department of Economic Affairs, right? Department of Economic Affairs, not Department of this expenditure. So this is also wrong. The term of withdrawal of money from the contingency fund of India is defined in the Constitution, right? The term of withdrawal of the money from the contingency fund of India is defined in the Constitution. So actually this is not defined. This is done through the executive actions. This is also wrong. Answer will be D. Question number 16 regarding the consolidated fund of the India. The consolidated fund of the India consists of all revenues received by the government of India. Yes, the consolidated fund of India, it receives all the money, all the revenue collected from inside the country. It also collects all the like the interest payment as well as all the loans which has been recovered from the various states or the various countries, right? So that is there. It receives the revenue received by the government of India, that is correct. provident fund deposits, saving bank deposits and the remittances. Actually all these things comes under the public accounts of India, right? Public accounts of India. This statement will be wrong. All loans raised by the government of India, so that is 100% correct. So 1 and 3 will be the answer. Question number 17. Consider the following statement regarding the Consolidated Fund of India. All the legally authorized payment on behalf of the government of India are made out of this fund. So that is 100% correct. All legally authorized payments are done on behalf of the government out of this fund, Consolidated Fund of India. The payment from this account can be made without parliamentary approval. Not a single penny can be taken out from the Consolidated Fund of India without parliamentary approval. So that statement is 100% wrong. So only incorrect has been asked. So 2 only will be the answer. So question number 18. Consider the following statements regarding public accounts of India. Judicial deposits and departmental deposits are credited to the public accounts of India. So that is correct. Actually NPS deposits, judicial deposits, departmental deposits, all these things comes under the public accounts of India. So this statement is correct. No money out of this fund can be appropriated, issued or drawn except in accordance with the parliamentary law. So that is not the provision. Actually the money can be expended from the public accounts of India through the executive actions. President is the holder and behalf of that